SJC-13854 in the matter of an impounded case.
Okay, Attorney DeDonna.
Good morning, Judge. Good morning, everyone. Chief Justice Budd and Associate Justices, may it please the court, Amy DeDonna appearing on behalf of the defendant appellant, Minor 1, who I will be referring to as John Doe today in my argument. Your honors have been very robust with your questioning today, and I expect the same will be true of my matter. However, I just want to start off by saying two things that I hope underlie everything that we talk about here today. The first one is that this is a 9-year-old child who simply didn't do it. He didn't do what was alleged of him. The lower court found that he did not do this. So what we're talking about today is punishing a child for something he didn't do for the remainder of his life. I'm calling it punishment because the harm is indeed substantial. Now, I understand that there's a distinction between harms that come from general access to public records or to court records. I understand and acknowledge that that is not the case here. Our concern, however, is the fact that it is extraordinarily ubiquitous these days for background checks to be done in connection with employment, in connection with foster care, with teaching, with medical jobs, healthcare jobs, a whole litany of different harms that I can certainly go down the list for you if you would like. For example,
but those again are all policy things, and I know you want to focus on the age of your client, but it's no different for the person that's subject to an ex parte order, comes back for a 10-day order, and the judge found that the ex parte was issued and it shouldn't have been issued because the defendant didn't do this. So that person is in the same position. So we really have to look at the statute. So, you know, you really haven't identified for us what authorizes expungement absent fraud.
So, Your Honors, what we're talking about here is, so you're referring to inherent authority of the court. So the inherent authority of the court requires the court to make a finding that by clear and convincing evidence that there was fraud committed upon the court. As Your Honors know, that standard is extraordinarily high, and I can certainly go through that if we—
Isn't that the only place where we've said that? Isn't that the metric? Fraud on the court?
Yes, Judge. So
if we don't have fraud here, what authorizes, and again, much like the last case, if you're asking us to do something new, just say it.
Yes, I am asking you to do something
okay.
new.
Why should we do something new?
Because of the manifest injustice that this rule causes to my client.
Right. So again, it goes back to where I started. That sounds like a policy argument, and isn't that for the legislature?
Well, Judge, I would say that it is somewhat a policy argument, but it's also a function of the juvenile court to ensure that younger litigants, especially younger litigants who did not do what they were accused of doing, do not carry a record throughout their entire life as a civil disability of sorts.
The argument is not so much, you know, what's the right policy here, because I can say for myself, I do have a lot of sympathy for your client and the consequences in the future for the issuance of the order to begin with. But we have not really free reign here, right? We have a statute that requires probation to continue to retain these documents even when, as you say, he didn't do it. So, you know, were that I had a magic wand and could make policy, you know, maybe I would have more power, but here the legislature has specifically instructed probation on the retention of such documents.
I would say that the legislature told probation that they needed to maintain these records and is silent on expungement. I understand that our jurisprudence in Massachusetts has led us to the conclusion that the only time that that inherent authority to expunge exists is if there is fraud. As Your Honors know, the fraud standard is very high. Some of the cases that I read, even about adults in preparing my briefs for this case, were pretty shocking to me in terms of what types of orders the court was retaining even though a person simply didn't do. So
And the
that-
rationale was the reading of the statute as
That's correct.
requiring, the legislature specifically saying, you shall retain these things.
Yes, and I do also want to point out that the juvenile courts have a different type of equitable authority when it comes to young children, especially innocent young children who have been determined by the court to not have done what they are alleged to do.
When you say that, what help us there? Because again, if I were in the legislature, I would fix this problem, but I'm not. And the statute includes juveniles. So it's like the legislature wanted this stuff retained for juveniles too. So when you say the juvenile court has these additional powers, or where in the juvenile, is there something in the juvenile statutes that we can turn to?
Yes, Judge.
Because the two cases on fraud are adult cases, right? The two out of the appeals court.
Yes, that's correct, Judge.
So is there something in the juvenile statutes that we can hang our hat on at least? Or-
Yes, absolutely. If you just give me a moment. Judge, so as I'm getting to that, the other thing that I want to point out, and I will answer your question, is that the inherent authority argument is protective of the courts and not of the litigants. So I think that's the distinction here, is that the judge in the juvenile court did not feel that this story, as it was presented by the plaintiff in the underlying matter, was impacting on the court's authority or the credibility of the court. However, is simply not true as it pertains to my 9-year-old client. So what we're talking about here is the inherent equitable authority of the juvenile court as it pertains to younger children. So that issue is not thoroughly briefed in my documents, which I can certainly supplement if Your Honor would like. But this is about a young child carrying this punishment essentially through his entire life.
we have all the language in the juvenile statutes about we don't want kids treated as criminals, but as kids in need of tending. And but that would require us to sort of carve an exception here. And again, it would be nice to have some authority for it.
So you think that,
It would, Judge, but that's why I'm at the SJC and not at the appeals court, right? So we don't have an answer to this question. We don't have a mechanism to protect this vulnerable litigant. There's no mechanism for us. So equitable authority, I think, is where we land.
you would think equitable authority of the juvenile court is broader than inherent authority?
Well, I do, Judge, because equitable authority has to do with the litigants, whereas inherent authority has to do with the functioning of the courts and the legitimacy of the courts. So I think we're talking about two different things there.
So I guess if I'm understanding your argument, you're saying that expungement, even if not necessary to protect the court, could nonetheless be ordered within the equitable authority of the juvenile court if necessary to protect the interests of
Of a
the
litigant,
juvenile,
do it.
of a juvenile, and that we would have authority where that, what would be the legal authority for that?
So that would just be the legal authority of the juvenile court, the equitable authority of the court.
Just,
Yes, and I understand that we have a statute here that is, yes, it gives exclusive jurisdiction to the juvenile court of these orders as they pertain to juveniles. So the juvenile court having jurisdiction, I think, does open up a broader range of potential remedies for Your Honors. I guess the question for me is, where are we finding the mechanism to ensure that we're not denying this kiddo justice for literally the rest of his life?
Well, I think there's even more to it than that, though, because if you're going to undergird this with the equitable authority of the litigant in the juvenile court, and you're in a tough position because typically the probation will send somebody in here in the cases in the past taking a position, so we have to kind of tease these out. The conceptual concerns that you're talking about are actual concerns for the adults in the adult docket, where the equitable considerations are even more pronounced. Because you have a child who's under the care of maybe a caregiver, a parent that's maybe has their housing taken care of, their expenses taken care of. Adults who have these wrongfully issued against them might have real consequences about jobs that they're trying to get or housing that they're trying to get, where arguably you could say it makes even more sense for us to have recognized an equitable authority on the adult docket to do exactly what you're asking us to do in the juvenile docket. So that leads to what is the limiting principle here? Because if that's the case, why isn't the lack of evidence suffice? Why not apply that to all vacated orders? Because that's what we have here. The judge found there was no evidence to support this order, and every day, thousands times a day in the community courts, there were 10-day, two-party hearings where judges find that the initial order should not have issued and there was no evidence to issue it. Why not just make it applicable to all vacated orders because of that?
So respectfully, Judge, I think we're talking about the developmental differences between adults and children, although I do agree that there are some.
Oh, I'm not talking about that. I'm talking about what you said. All of the parade of horribles that flow from this order, and that's applicable to both people. And again, might be even more acutely to the adult that needs to get the job or get the housing.
Well, Judge, I'm not here arguing on behalf of adult litigants, but I do know that Your Honor and this panel can narrowly construe an exception to, say, Vaccaro, which requires that the court use inherent authority and can only do so in an instance of fraud, which is an incredibly difficult definition to meet, which I think you'll see in my trial documents. I argued that there was fraud and that the judge found that there was not. I certainly disagree with that finding, but that's not why we're here. We're talking about Vaccaro. We can carve out exceptions. For example, a juvenile who didn't do it. That's a very simple way for me to look at this and say, this is a limiting principle. This is a limiting principle that's appropriate and is appropriate to enable juvenile litigants to get justice. So I understand what Your Honor is saying about a more pronounced impact on adult litigants. However, the impact is the same. The impact for this child, which began at 9 years of age, will never go away, and it will follow him throughout the rest of his life if this remains on his record. So the impact will be the same. The public housing, MIAA, I'm sure all of you are familiar with. In order to coach, ref, do any of the things that people do with kids, they need to have a background check and they need to be cleared. Adopting children, working for DCF. You know, there's all sorts of ways in which this child's opportunities will be limited by virtue of him having to submit to a background check that will show that he has not just a harassment prevention order, but he's on the domestic violence registry, which is also an issue, that all 209As and 258Es end up in that same bucket, which arguably is problematic. However, that's how probation does it. So
they stay on that registry even if it's been vacated?
If the order is vacated, yes, that's exactly the position we're in right now. The order is vacated. The judge actually vacated his order back to its inception. So, which was, me trying to get around this argument of, well, if the order never existed. The problem here is I'm asking you to vacate an order that existed. And the very fact that that order existed means that a judge looked at this situation at a two-party hearing and made a determination that my client willfully and maliciously caused fear or harm to another person 3 or more times. It's simply not true. So anyone that looks at that on a Corey, on a Carey, on a III report, on the domestic violence registry, all they know about it is that it existed and that the finding had to be made that 258E was implicated, and therefore...
And it was vacated.
And it was vacated.
Vacated 2 weeks later.
Absolutely, Judge, but this court's own jurisprudence...
And he was 9 years old when this happened.
I don't disagree with you, Judge, and interestingly, to your point, is that juveniles in Massachusetts are not even criminally responsible or anything until they are 12 years old. So in the event that there was a violation of this order, what would we have done then? That's a separate issue, but interesting to think about in terms of the developmental appropriateness of us, doing this kind of thing with kiddos. So I want to make sure that we're clear that there is actual harm and that we're clear that my client didn't do it. And I think that the didn't do it part and the juvenile part, those are the parts that I'm asking your honors to focus on. I think that's what gives us an appropriately narrow exception that allows us to protect vulnerable litigants who have been, essentially falsely accused and brought into a process that they shouldn't have been in to begin with.
Okay, thank you.
Thank you, Judge.